Welcome back to this month's episode of the Hearsay Podcast with myself, Cory, and co-host Laura. Just a quick reminder that this is legal information and not legal advice. With that, I'll hand it over to Laura to get us started.
Today, we have Professor Kamaal Zaidi back on the podcast. In his previous episode this year, Professor Zaidi was discussing immigration law, but today we have him on to talk about another one of his areas of expertise, contracts. Thank you for joining us again.
Thank you for having me. I appreciate it.
Everyone has some sort of experience with contracts, whether it's an employment contract, a lease, or clicking I agree to a service provider's terms and conditions. But a lot fewer of us have probably thought about what a contract really is and what essential elements need to be present for a contract to be enforceable. We were hoping you could give us an explanation about what a contract is in its most essential form.
Yeah, I'm happy to do that. A contract is one of those agreements between two or more parties that accomplish an objective of some kind. It doesn't have to be related to money. It could be related to a service or anything else. It could be even something charitable in nature. But most of what we do in our world is a contract. The fact that you have me here answering your questions, you both of you reached out to me initially and asked this question, can you come in and provide answers to certain questions on contract law? And I agreed by email and orally as well. I could have taken another approach and just refused, but I'm here because of that agreement. In that agreement, we had specific terms and conditions that, you can meet us at this time on this day, and we can have our recording at this time and so forth. But having digested all of that, I agreed to that. It's no different from parking in the art parkade like I do and paying, $12 a day. That's a contract too, as opposed to, say, getting a subscription to an app on my phone or tablet. And so, we acquired those apps, we use those apps, and that's a contract as well. If I fill up gas at a gas station, that's a contract. Everything we do is virtually a contract, whether it's in writing or orally. It could be express or implied, but the great bulk of our world and civilization is based on contracts.
Thank you for that. I think you've covered some of this next question, but we just wanted to lay out for everybody what are some of the essential components that are required to move something from being just an agreement into something that is legally enforceable.
Yeah, that's an excellent question. So in terms of the law, we look at contracts that are communicated between parties based on usually 6 elements. So you have offer, acceptance, consideration, intention, legality, and capacity. And the idea is that all of these elements have to be there in order to form a valid contract. If any of these elements are missing for whatever reason, then it can be argued that there's no enforceable contract. First, there's a contract of formation which forms legally. I agree to meet you for coffee at 2:00 this afternoon at a local Starbucks or Tim Hortons or whatever your preference is. And the idea is that there's no money involved in terms of us meeting. We're just meeting just to meet each other. Is there an offer in that? Is there any form of acceptance? I could say no. I could say yes, but then my friend forgets, like they usually do. And am I agreeing, or both of us are agreeing to meet at a specific time and a day and a place? You have this idea of consideration. We're both giving up something, or we're both putting in some value of some kind. It could be a service, it could be anything like that, but I'm giving up time to meet you. And then you have intention, legality, capacity. It's not an illegal contract, at least I'm hoping it isn't, to go meet someone for coffee. And then you have this really important element called intention. What is your good faith intention in forming an agreement? Why are you meeting me for coffee? Maybe it's just friendship. Maybe we're trying to run away from our homes because our families are driving us up the wall. Maybe it could be the fact that there's some business to discuss. Maybe we have a personal thing going on and we're trying to discuss things. It could be for many reasons, but intention often is something that courts look at when there is a disputed contract and when either of us dispute that agreement. And of course, capacity has to do with our sense of awareness, our understanding that we can legally enter into contracts by virtue of age, sensibility, in terms of being aware of our surroundings and being of sound mind, right? It's difficult to sign a contract with someone who's intoxicated or high on some medication or drugs, or just someone who's facing a mental health issue. So these elements are very, very critical to form even the simplest of agreements.
Thank you for that overview. You've also touched on this a bit already, but we wanted to get your opinion on the role of contracts in our present day. A lot of the cases we talk about when learning about contract law are based in Old English cases. They're about horses and situations that don't seem very relevant to us today. So we just wanted to get your take on the role of contracts in our modern society.
We have been teaching contracts since ancient Greece, and I was there because I know. The idea is that with contracts, it's such an old subject that it has to be taught in law school in first year, very much like anatomy, physiology is taught in medical schools. So when you're going through the basics of any law course, it's painful when you first learn it because nobody knows what it is. But once you get to know it, it's so foundational to our learning and understanding of law. When you practice with your first client, your first file, and there's no law textbook in front of you now. There's no law professor who's before you explaining things. That's when it hits you, what is a contract. And so, from the early English cases, we see common law precedents being developed. But contracts have been around longer than that. Since the ancient world of trading by ship, commerce has always been there. And the law of the sea, admiralty law, is one of the oldest forms of contracts in the world, including insurance. When you look at Lloyd's insurance company in England, that's been around for hundreds of years. So contracts are very old. It's been part of religious custom. So when you have a contract of marriage in different cultures and religions, contracts are deeply rooted in religion and faith. And when you're looking at modern day franchise law with Burger Kings and Tim Hortons, Boston Pizza, whatever you're having, I'm not endorsing these places, by the way, but these are all based on franchise agreements. So you have these very ancient agreements. Sometimes it's just an exchange of goods. Like in the old days, in the medieval times, they used to, the seller would give a piece of dirt and put it in the palm of the buyer. And they would take that and they would eat it. No, just joking. And they would actually transfer title that way. That was the old way of transferring property. So it's a question of what is your custom. We've had contracts from the very beginning of time, and it's just that it's become more of a formalized document, very much like a contract of marriage or a real estate purchase contract or whatever you're doing. Student loan agreement, something that all of you are definitely involved with nowadays, and I used to be involved with. The idea is that those contracts, they rule our life, and for that reason we have to teach not only the principles of contract law in these cases that we study, but also look at history as well. History is ripe with contracts. And when you look at declarations and independence movements, like the Declaration of Independence, and these are all essentially contracts to the people from the government that we promise to, form a nation and do all these different things, which sometimes is undone. But the idea is that it's a contract. It's something that can assure people that certain things will be done, obligations will be performed, and most important, that promises will be kept. That's the very, very important one.
Thank you for that explanation of what contracts really are. We also wanted to talk about some specific cases, so I'm going to hand it over to Cory to talk about our first case today.
So we picked out some interesting cases we thought would be a good way to highlight some of those core components of a contract that you discussed earlier. With some restrictions, people have fairly broad discretion to set and agree to contract terms that they may later come to regret. We wanted to talk about a case out of Virginia in the mid-1950s, Lucy and Zemer. In that case, two friends were at a bar, they had a bit to drink, and they spent about 30 to 40 minutes discussing the sale of Zemer's farm to Lucy. Zemer ended up writing on a piece of scrap paper, "We hereby agree to sell to Lucy the Ferguson farm, complete for $50,000, title satisfactory." Both Zemer and his wife signed the note. When Lucy later tried to proceed with the transaction, Zemer claimed it was a joke. The dispute went to court, where the note was found to actually be a contract. Can you tell us a bit about the reasoning that went into this decision and why the court decided this note was a contract?
Yes, absolutely. Those are very prescient facts because they go to the intention of parties, and it goes to the element or the elements of forming a contract, and the fact that you can't joke around when you are forming an agreement. What we have to look at is, with these 6 elements I was talking about before, have they been fulfilled? And more importantly, what are the circumstances of this case that can attribute to some formation of agreement, even though it was intended as a joke? We know when people jest, when they joke. We also might be inebriated. We might be in that kind of playful setting where a contract is probably not going to form, but we're talking about it nonetheless, that I would like to purchase the Calgary Flames for $1. Okay, and maybe that's what it's worth nowadays, but I'm not sure. But the idea is that, the Calgary Flames was purchased as a team on a napkin. And when you give the offer that way, is that in jest? It doesn't have to be, especially when someone who is making the offer has the money to pay for it. So it's a question of, in Lucy v. Zemer's case, they have had actually a history of dealing with each other. They knew each other from the past. And in many instances, there has been a proposal to purchase the farm, Ferguson Farm. And it's just that it was always shot down. So the question is, what is so special about this offer at this point in time? Given the fact that they drank whiskey and they had, who knows what else they had, maybe a burger. But the idea is that what prompts the court to look at this circumstance, and a lot has to do with their course of dealing, with their history of relations, but it also has to do with the fact that, there is more than just joking going on here, because something is written. And not only is it written, but it's written with great specificity. If you are really intoxicated or inebriated in some way, you might say that, yes, I'll sell my house to you, okay, just in a joking manner. But if I indicate the purchase price and the date of possession and all that, I don't think I'm that inebriated, am I? And that's kind of what the court was looking at here, is that there was a lot more going on in this offer than meets the eye. So there was a great deal of specificity and understanding. So capacity came into play, intention came into play. And with all those 6 elements in place, you have this history of a relationship between these parties. They knew each other, and they have dealt with this issue in the past. It's just that it was in the negative. So at what point do we recognize a contract that seems to be made in jest, but actually carries a lot of commercial significance. We don't want to just do away with agreements that actually can form a contract simply because it's made as a joke. Sometimes people don't joke, and they really mean what they say. And you can't just use that as an excuse every single time you want to purchase something valuable like land. I mean, we're talking about land here. We're not talking about someone's, computer speakers or something, or something of it, like say a cell phone or something. This is land. This is worth $50,000. It has a lot of value. What intention does someone who's drinking a little bit, but still understands enough? What are they thinking about this land? Because that is a big asset to carry.
This is an American case, but one of the principles that come out of it is that the standard for determining intention to contract is objective. Is that standard generally applicable in Canada as well?
Yes, it's a good question because it goes back to English common law. And both Canada and the States have adopted the English common law long ago in terms of, embracing these elements. And so when we look at the objective standard, that's when we test to see what an average reasonable person, meaning someone who's an adult of sound mind, who can appreciate the same situation, what would they have done in a similar circumstance to Lucy v. Zamer? So you have this situation where the court has to sort of ask that question out of objectivity, not subjectivity, which is what you think. In the law, we try our best to look at both, subjective and objective, but we focus on what would be the average reasonable person thinking about this contract. Would they view it as being a serious offer to purchase a farm, or is it just a joke and it's meant to be a joke? Maybe it's a practical joke even, okay? And there are tons of TV shows on that. So it's just a question of how we take a very old English common law principle of objectivity and how we are applying it in today's world, in Canada and the U.S. And both countries are common law countries, so they will adopt that principle and go with it. So yes, it does still apply in today's world.
Okay, thank you. That is all the questions I had for this case, so I'll now hand it back to Laura.
So we have another older case, also out of the States, that we wanted to talk about. In this case, Hamer and Sidway, 1891, the New York Court of Appeal faced a simple but powerful question about what counts as a real contract. An uncle promised his nephew $5,000 if the nephew would refrain from drinking alcohol, using tobacco, swearing, and gambling until he turned 21, keeping in mind that $5,000 is a lot of money in 1891. The nephew accepted the deal, fully complied, and when he reached 21, the uncle acknowledged the debt but died before paying. This led the executor of the will to argue that there was no contract because the nephew gave nothing of value in return. The court rejected that argument, holding that a contract is supported by consideration when one party gives up a legal right at the request of another, even if the forbearance benefits the promisee rather than the promisor. Because the nephew surrendered his legal freedom to engage in those activities on the reliance of the uncle's promise, the promise was enforceable and the estate was required to pay. We were wondering about this case in a modern context. There is a presumption that agreements between family members may lack an intention to create legal relations. Do you think that a Canadian court would still uphold a contract like the one in Hamer and Sidway?
Yeah, it's a great question because contracts are enforceable between family members, particularly when there's a will in a estate situation or matrimonial property, which is what we call family property now when you divide assets after a divorce or separation. So these kinds of contracts are enforceable between family members, even though it's of a domestic quality. And you're right about one of the old rules in contract law where, generally speaking, we don't hold contracts to be enforceable for every single domestic dispute, because it can lead to a great friction within families, and it's just not good in terms of public policy. At the same time, you should see how many people out there are engaging in huge legal disputes and their family members. especially when mom and dad die. Oh my goodness. You should see the real definition of a family there. Okay. And in those instances, you have this issue where, like the uncle, it's always an uncle, who's leaving something profitable behind to a nephew who has actually demonstrated in good faith to meet the obligations set forth by the uncle. It's just that, as you mentioned correctly, the uncle acknowledged the debt, but indicated in that specific case that you won't get the money until you can demonstrate that you're capable of handling it. And then that's one of the reasons, actually, the uncle and the nephew had the same name, William Story. One was junior, one was senior. But the idea is that eventually the case transferred to the executor of the estate and the assignee, which was appointed on behalf of the nephew. So the two Mr. Stories actually had their names changed to Hamer and Sidway because of the representation of those two people, one being dead and the other still being alive and wanting the $5,000. And as you mentioned correctly, that was a lot of money back then. And so in terms of handling domestic arrangements and whether or not we can make promises enforceable, one of the things the court did in that case is kind of view the issue of consideration and what does that mean exactly. Part of that is what you mentioned, forbearance, which is giving up something, which is in this case the nephew giving up his legal right to drink, to gamble, to smoke, all the wonderful things in life, right? And, maybe I would have included to watching hockey games and things like that, but that would really probably break the deal. But the idea is that the nephew did everything that the uncle asked for. Again, was that a joke? Was that just a kind of an idle promise? Was that made in jest? No, it was real. And the uncle acknowledged that yes, you've turned 21 now and you have abstained from many of these things that would definitely benefit someone and add to their health. And that's actually what the executor of the estate of the dead uncle said, that if anything, you benefited from this because you didn't drink, you didn't smoke, you didn't do all these things. You're this very fit, young, healthy man who wants $5,000, right, which you're not going to get. So good for you on your health and all that, but forget it. And the court said, no, you can't say those things because part of giving something up, that forbearance, is a type of consideration. It's not just giving up money or a service or time. It's also giving up your ordinary legal rights. And nothing stopped this nephew from drinking, gambling, smoking, and all of these things. Nothing prevented it. He was actually entitled to do these things. But because of the intention of his uncle's promise, which is, to essentially provide kind of moral guidance to his nephew, that, just be a good person according to the uncle, who's probably doing the same things that he's telling his nephew not to do. That's something that it goes back to intention. It goes to consideration that giving up something I'm legally entitled to do is consideration. So that becomes an element of the contract. And that's one of the reasons why they enforced it, because you had all of the elements there.
Yeah, it's just a different imagination of consideration, the lack of doing something.
That's right. And most people don't think of what the nephew did as giving something up. The way we would give something up, say in a student loan agreement, we have to work, make some money, and start paying back in installments. Our obligation that's what most people think about as an obligation, but that also could mean giving up something that you're entitled to do.
Thank you for that explanation. We next want to turn to contracts and technology, so I'll hand it back to Cory for our next case.
So, with the future of with technology developing and contracts, obviously a part of that, contracts is an area that's uniquely kind of being affected by recent technological developments. So the case that we wanted to discuss is the emoji contract. It's a recent case out of Saskatchewan. Atcher Land and Southwest Terminal Ltd. received a lot of media attention because the court found that a thumbs up emoji was sufficient to fulfill the signature requirement of a sales of good contract. In that case, an employee from Southwest Terminal, which is a grain distribution company, texted the contract to Atcher, who is a flax farmer. Atcher replied with a thumbs up. Later, Atcher did not deliver on the flax and Southwest sued for breach of contract. Atcher argued that there was no agreement, and secondly, if there was an agreement, it wasn't valid under the Sales of Goods Act, which requires a signature. In a divided Court of Appeal decision, the court held that the contract was binding. With the general informality of modern communications, do you foresee more developments in this area of contracts and technology as a whole? And how do you find this case in general? Is the outcome surprising to you?
It's a very interesting question, and technology will always change the means of acceptances. That has been going on for thousands of years in terms of people looking at historical documents or contracts, constitutions even. In the old days, wills, people used to put X by their name. They didn't even sign their name because, a lot of people were illiterate, so they didn't actually know how to spell their name. I know it sounds funny, but in those days, that was one of the cultural norms. Today, we can use I agree. We can use just our signature. We can sign. We can click on boxes online. And then now we have this technology where we're using emojis. I try to limit my emojis in my emails as much as I can, but it does express words. So when you look at the quality and meaning of an acceptance, we often shake hands. I have taught my students and all of you guys that silence is usually not acceptance. But if you show some kind of expression of or manifestation of interest with acceptance, in what form will it take? I can say it verbally. I can sign the contract, as they say on the dotted line, or I can email back, which we never used to prior to 1995. We didn't have the internet. There was no means of acceptance that way. We used to have fax machines. You remember that? And if you want to go down museum history, then just come to my house. But the idea is we used to deliver faxes in the old days, and many law firms still kind of use faxes just in case the email breaks down or, someone has, hacked into their computer, which is sometimes it happens. How can you communicate a message? I can send my carrier pigeon with the little note tied to it that I agree to purchasing the Ferguson farm, right? I can do a lot of things. The emoji has just kind of indicated a modern-day acceptance using technology on our phones or tablets, and it is an expression of our words. So if we can use words as acceptance, why not use gestures or indications of that? If there's no wanting to purchase grain, like in this particular case, then why would you even communicate at all? Now, and again, going back to the history of this case, the parties knew each other, and they have often communicated their contractual transactions in language using the phone, using text messages. They've done this in the past. But it's just that this time you have an emoji, and that emoji is it's taking the form of a word, but it is involved with all the other elements that we talked about. There is an intention, there's a offer, acceptance, consideration, and capacity and legality. So everything is there, but for the emoji. So I agree with the court ruling that an emoji can be serving as acceptance. And in the future, maybe something else will that doesn't necessarily relate to normal communication the way we communicate. We might have an AI chatbot or AI robot who's supposed to be cleaning my house right now, and maybe have them enter into contracts with others. I foresee a world where technology is such that, AI is going to not necessarily rule everything, but it will do a fair portion of our negotiating and work. We may not even have lawyers who are human. We may have AI lawyers instead because they're much more reliable. So it's a question of, starting from this emoji issue, can we recognize new technology for old legal principles? Yes, is my answer.
And perfect. And that kind of builds into our next case we want to discuss with even more recent technologies such as AI development. I'll hand it off to Laura for that one.
Coming out of the BC Civil Tribunal, Moffat and Air Canada is a case where a chatbot on the Air Canada website gave Mr. Moffat incorrect information about bereavement fares. Air Canada claimed the chatbot should be seen as a separate entity from Air Canada, which would absolve the company of any liability in having to pay Mr. Moffat damages for the difference in fare price. The tribunal rejected the argument from Air Canada and found that Mr. Moffat was reasonably relying on information given to him from the chatbot and that Air Canada was responsible for the chatbot's representations. While the Moffat case is about negligent representation more generally, it raises some interesting questions about AI automation in the world of contracts. You've already touched on it a bit, but we were wondering if you had any thoughts on the potential impact of AI on the formation of contracts, such as who or what is recognized as a contract party, and what potential legal challenges we might see in the area of AI and contracts.
It's a loaded question with full of policy and principles. The idea is that with AI in general, it is becoming a big part of the law. It has already become a big part of the law. Our legal research often includes it. In the case of a lawyer who's not ready for court, they will quickly ask the question on ChatGPT and get usually the wrong answer, but they will still go with it, and only to be judged by people who know better. But the AI in terms of chatbots on an airline website represented to consumers who are purchasing a ticket or returning something or inquiring about basic services in the case of bereavement fees and bereavement in general. In that Air Canada case, you have two representations. One was, representation of bereavement, the bereavement process through Air Canada on one page that has one set of facts of what the procedure is, and the AI chatbot, which is giving completely different information. And one of the things that the court looked at in awarding the case to Moffat is that you're dealing with two types of representation, which is confusing in itself. And it led to that negligent misrepresentation. But more importantly, the control of AI on those websites. So if you are, as Air Canada indicated, that we are not responsible for this chatbot, which is a separate legal entity. And when I read that, I'm like, you got to be kidding me. Because, yes, there's a corporation, which is a separate legal entity. We can incorporate a business through any Alberta registry, no problem, or federally. That's a legal entity. That's an estate is a separate legal entity. Each of us individuals are separate legal entities. But a chatbot that has been designed by you, and is being controlled by you, and is being used for customer service. How can that be a legal entity unto itself? When you are an airline, you control content, you control information that is relied upon by consumers, like Mr. Moffat. And he was given two pieces of different information. What is he supposed to do? Gamble? Is he supposed to flip a coin or something? Or how confusing is that communication to the consumer who's simply asking just one question? And I agree with the court's ruling and rationale that Air Canada had full control of its content, including its AI chatbot, and that it's not a legal entity unto itself. It's simply used as a device to sell Air Canada and everything related to it. But to say that a chatbot is a separate legal entity, what are you doing with that separate legal entity on your own website? And if it has different information, doesn't that contradict what else you're showing on the website? That's not a good website. Any IT person can tell you that, right? And I'm not an IT person. But the idea is that, it goes back to negligent misrepresentation. But what's a very interesting modern twist to it is the role of AI, which we're still trying to figure out and understand. We don't know what the role of AI is in the law yet. We are discovering it. We're evolving. We learn, just like we did with COVID, but we're not there yet. So I think you'll see more and more cases like this, not just against airlines, but just in general. If I sign a contract with an AI entity, is that a contract? Maybe something to think about. The thing is, we do use AI every day. I mean, I buy things from different websites, and most of that is AI content, or I might be on some kind of messaging, kind of a chat where the online chat mechanism is an AI. It's not a human being, and maybe it is, but some human beings act like AI. But the idea is that is that a legal contract between myself and an artificial entity? It could be, but many companies like Amazon or Walmart or whatever, they use AI chatbots or mechanisms to sell their products and services. It's just a part of the marketing, right? And we engage in that as if it's nothing, and we're so used to it now. So I think that's why the court ruled that way in this case.
Thank you for that future-looking explanation. With that, we are coming close to the end of our time here, so we wanted to thank you for coming on the podcast again, giving us a very quick overview of what a contract is and discussing some of the different ways that the essential elements of a contract can be challenged by different weird circumstances. So thank you so much for coming on again today.
Thank you. It was a pleasure. Merci beaucoup. And I look forward to hearing the podcast and to hear my own voice and all of yours as well. So thank you.
Thank you so much.